Good evening, everyone. Can I welcome those attendees who are present here in Brisbane in person, but also I understand we have around 150 or more registered to attend and who are viewing presentations online. Can I just, in terms of housekeeping, mention who are viewing the presentations online that if you wish to submit questions to the speakers, you will find there is an icon, a speech icon bubble at the bottom right-hand corner of your screen. You can submit your questions by typing the questions there using that bubble, and they'll come through to me, and then I will direct them to our speakers. We think we might do the speeches first, the presentations first, and then we questions after that. That's probably the most convenient way to deal with the matter. Now, by way of introduction, my name is Sandy Thompson. I'm the Solicitor-General for Queensland, and I have the pleasure of chairing tonight's session. Can I say something about the topic before introducing our speakers? So the words trade, commerce and intercourse in section 92 of the Constitution are stated as a composite expression, and until 1988 the High Court had not treated trade and commerce on the one hand and intercourse on the other as substantially different. That all changed, of course, with Whitfield in 1998, which marked a turning point in the jurisprudence in respect of section 92. The trade and commerce limb was thenceforth interpreted as precluding discriminatory burdens of a protectionist. But what about that part of the riddle of section 92 as it was described by Justice Gageler, which was left unresolved by Whitfield, the intercourse limb? And does structured proportionality have an application in justifying burdens upon intercourse? These parts of the riddle came before the High Court recently in Palmer and Western Australia. Judgment was delivered on the 24th of February 2021, and that case is the subject for our speakers this evening. They are both very qualified to address and answer the riddle. Indeed, our first speaker, Jeremy Kirk, Senior Counsel, was credited by the High Court with answering the intercourse riddle in his published essay, Section 92, in its second century, which was published in Griffiths and Stelios editions, Current Issues in Australian Constitutional Law, Tributes to Professor Leslie Zines in 2020. Having given that acknowledgement to Mr. Kirk, it is, however, necessary to further point out that the essay was only given the prominence it received in the case because the Attorney-General for Queensland intervening
well represented.
Advanced it in support of the proper interpretation of the intercourse limb, a submission expressly recognised and accepted in emphatic terms by the judgments of the joint judgment of Justices Kiefel, Chief Justice, and Justice Keane, recognised, although less prominently, by Justice Gageler and referred to by Justice Edelman as forceful. Mr. Kirk's paper, Constitutional Guarantees, Characterisation and Concept of Proportionality in 1997, published in 21 Melbourne University Law Review, was also referred to in the reasons, but dare I say again brought to prominence in footnote 86 of the submissions by the Attorney-General for Queensland intervening. Our second speaker is Shipra Chordia. Shipra's work on structured proportionality, proportionality in Australian constitutional law, published by Federation Press in 2020, was also cited extensively by the High Court in Palmer. However, again, I have to note that the passage from the text referred to by the Court were passages footnoted in the submissions of the Attorney-General intervening. Jeremy Kirk of Senior Counsel was called to the bar in 2002. He was appointed Silk in 2011. He has an extensive practice in varied areas, both in New South Wales and across Australia. He holds degrees in arts and law from Australian National University. He received a university medal in law. He attended the University of Oxford as a Rhodes Scholar, where he was awarded a Bachelor of Common Laws and a doctorate degree, and he was a recipient of the Distinguished Venerian Scholarship at Oxford as the leading BCL student. He's included in publications including Best Lawyers, really from its inception, Chambers and Partners rankings, and as a leading senior counsel in Doyle's Guide. And he's appeared in a number of notable High Court cases, including recently BMW Australia and Brewster, involving the validity of common fund orders in class actions, Spence versus Queensland, Reed Day, and in McCloy, a constitutional case in relation to political donations, as was Spence. Our second speaker, Shipra Chordia, is a barrister at the New South Wales Bar, a member of New Chambers. Shipra was called to the bar in 2018, but before that had an extraordinarily distinguished career, having been a solicitor with Freehills in Sydney, subsequently at Linkladders in London, and serving also as a judicial assistant to Lord Justice Mummery in the Court of Appeal of England and Wales. She has held the positions as a visiting researcher at Harvard Law School, a research fellow at the University of New South Wales, and from 2014 to 2018 she lectured in public law at the University of New South Wales. She has been the author of a seminal work on proportionality in Australian constitutional law, which was the publication I mentioned as the one referred to on no less than 10 occasions throughout the judgment in Palmer and Western Australia. I've discussed with Shipra, although I haven't done so with Jeremy yet, the order in which we might proceed, and we've agreed, Jeremy, that you should go first.
Well, thank you very much, Sandy, first for your kind words today, secondly for your excellent footnotes in the submissions on behalf of the Attorney for Queensland, and from the sounds of it, I'm paying for dinner tonight. Can I also say what a pleasure it is to be here in person at the Queensland Bar Association, having, on perhaps an old-fashioned view, exercised my rights of intercourse to come up from Sydney yesterday, although we'll get to such rights as I have shortly, and having earlier today had the pleasure of, on one view, exercising my Section 117 rights to appear in the Court of Appeal today here in Brisbane. Palmer and Western Australia. It is, as Sandy alluded to, the first case to grapple with the intercourse limb of Section 92 since Colin Whitfield, to use perhaps a slightly provocative term, disintegrated the two limbs of Section 92, the trade and commerce limb, as it came to be called, and the intercourse limb back 33 years ago in 1988. Can I outline how I propose to proceed today? First, I'll just outline what the issues were in Palmer and Western Australia. Secondly, deal with what might be called the intercourse dilemma. Thirdly, the resolution of that dilemma. And then fourthly, make some comments about, comments with which Peter Dunning may have some sympathy, about the complexities of challenging exercises of statutory discretions, because that in the end was a key issue on which the resolution of the case turned. So what was at issue in the case, perhaps obviously enough, was the constitutional validity of the border closure measures taken by the West Australian Government. And in brief, they arose in the following statutory context. Section 56 of the Emergency Management Act 2005 of WA provided and provides that the relevant minister may declare that a state of emergency exists. And indeed, state of emergencies have been declared all around the country under equivalent legislation, I think, in every state and territory over the last 14 months. In WA, they're only authorised to do so if, amongst other things, the minister is satisfied first that there is an emergency, being the actual or imminent occurrence of a hazard of such a nature or magnitude as to warrant a significant and coordinated response, and one of the things to which there may be a response is a hazard, including a plague or an epidemic. Secondly, the minister has to be persuaded that extraordinary measures are required to prevent or minimise, amongst other things, loss of life, harm to health or safety, or so forth. Such a declaration of the emergency remains in force only for 3 days when first made, but then can be made for a 14-day period at a time, and indeed kept being made. I don't know if it's still in place in WA at the moment, but for a long period of time, every 14 days, it would be renewed. When the declaration was in force under that piece of legislation, as for equivalent legislation around the country, various powers then come into play, and relevantly that included a power under section 67 of the Emergency Management Act, which enabled directions to be given restricting movement into or out of the emergency area. What was the emergency area? The whole of the state of Western Australia. So that declaration was first made on the 15th of March last year, just over a year ago, and was extended from time to time. The relevant directions were actually made by the Commissioner of Police under the Act, and they were aptly named the quarantine closing the border directions, closing the border close bracket directions, which took effect beginning of April last year, in fact a year and 2 days ago. So there's not a lot of ambiguity about what they did. The effect was to close the border of WA to all persons from any place unless they fell into a category of exempt travellers. Mr Palmer did not fall into one of the categories of exempt travellers, and he wished to travel to Western Australia from Queensland, not least because he's engaged in litigation and arbitration proceedings in Western Australia. So proceedings were commenced in the original jurisdiction of the High Court on the 25th of May last year. On the 16th of June, half a month later, the Chief Justice of the High Court remitted part of the matter to the Federal Court, being, quote, so much of this matter as concerns the claim by the defendants, Western Australia, of the reasonable need for and efficacy of the community isolation measures contained in the directions. Justice Rangia in the Federal Court sitting here in Brisbane was the lucky judge who got allocated that part of the matter, and he conducted a hearing in the last week of July last year. His role was essentially to find facts, which His Honour did in a long and relatively quick, with great respect, judgment. He found a whole lot of facts. I won't recite them all, but just note perhaps 3 of them. First, he found that the border restrictions had been effective to a very substantial extent to reduce the probability of COVID-19 being imported into Western Australia from interstate. Perhaps an unsurprising fact. If you stop people coming in, you stop the vectors of disease. Secondly, the probability of persons infected with COVID-19 entering WA in a hypothetical scenario where the border restrictions are removed cannot be accurately quantified because of the substantial uncertainties involved in predicting all the relevant factors. It's hard to say what the degree of risk would be if the border closures were lifted. Thirdly, for my purposes, His Honour said, based on the evidence currently available, the following qualitative assessments of the probability that persons infected with COVID-19 would enter if the border restrictions were completely removed were from Victoria High. You'll recall His Honour was sitting in the last week of July, writing beginning of August, which was just when the second outbreak was occurring in Victoria. New South Wales moderate, Queensland uncertain, South Australia, ACT, Northern Territory low, Tasmania very low. So there was a spectrum of qualitative assessments that could be made. Once Justice Rangia had made those factual findings, the matter returned to the High Court. Legal argument was heard on the 3rd and 4th of November. The Court handed down its orders on the 6th of November and published its reasons in February of this year. Now, as for the nature of the legal challenge, Mr Palmer alleged that the directions made by the Commissioner of Police and or the authorising provisions in the Emergency Management Act infringe Section 92, mainly on the basis that they unduly burdened interstate intercourse, and what seems to have been a secondary argument that there was also a discriminatory burden of a protectionist kind, such as to fall within the Trade and Commerce limb. Importantly, the challenge was framed as one based only on direct constitutional grounds. It was not argued that the directions were not authorised by the Emergency Management Act. I'll come back to that at the end. Only 5 judges sat on the matter because of the timing issues concerning retirements. The court's unanimous answer in the end was that the statutory powers, quote, in their application to an emergency constituted by the occurrence of a hazard in the nature of a plague or epidemic, in statutory terms, comply with the constitutional limitation of Section 92 of the Constitution in each of its limbs. It also stated in its answer that, quote, no issue is taken as to whether the directions were validly authorised by the statutory provisions, so that no other question remains for determination by a court, unquote. So, to put it not too cruelly, I hope, the court sidestepped the issue as to whether the directions themselves were valid as having been authorised or not by the statute, on the basis that the court took the view that that had not been put in issue by Mr Palmer. Let me turn then to what I called the intercourse dilemma, and as Sandy said near the beginning of his remarks, and as you all know by heart, Section 92 of Australia's Constitution guarantees that, quote, trade, commerce and intercourse among the states shall be absolutely free, unquote. The framers didn't specify absolutely free from what, and no doubt they meant governmental restrictions, but what type of governmental restrictions? No one could sensibly suggest they meant all governmental restrictions, such that you simply have, to quote one case, an Alsatia. Anyone coming from interstate can do as they will without being bound by the law. In Cole, as you also know, the High Court unanimously resolved vis-a-vis the Trade and Commerce limb that it was directed to laws which imposed discriminatory burdens of a protectionist kind. And this approach involved rejecting past approaches which saw Section 90, well in fact was a range of past approaches, but one of the leading past approaches had seen Section 92 as guaranteeing an individual right to engage in trade and commerce across state borders. In Cole, the court didn't seek to resolve the reach of the intercourse aspect of Section 92, but it did feel necessary to address a perceived argument that the intercourse aspect of Section 92 required a broader construction of the guarantee vis-a-vis trade and commerce than the court sought to give. So it saw intercourse as a potential impediment to its view of trade and commerce, so it had to deal with it. It held it could put the guarantee vis-a-vis intercourse to one side because, quote, the notions of absolutely free trade and commerce and absolutely free intercourse are quite distinct, unquote, and that, quote, there is no reason in logic or common sense for insisting on a strict correspondence between the two. Nevertheless, the court stated that, quote, the constitutional guarantee of freedom of interstate intercourse, if it's to have substantial content, extends to a guarantee of personal freedom to pass to and fro among the states without burden, hindrance or restriction, unquote. You might contrast that language of a guarantee of personal freedom with their rejection of the individual rights view vis-a-vis trade and commerce. The court added that, quote, it's clear that some forms of intercourse are so immune from legislative or executive interference that if a like immunity were accorded to trade and commerce, anarchy would result, unquote. So it's quite plain from the judgment in Cole and Whitfield that their honours saw intercourse as having more bite, in a sense, than the trade or commerce limb, thus the language of guarantee of personal freedom, and that if we did for trade and commerce what intercourse did, anarchy would result. Since Cole and Whitfield in 1988, there have been literally a handful of cases in the High Court dealing with the trade and commerce limb, and another handful dealing with the intercourse limb. which contrasts incidentally to the 140 odd cases that had preceded Section 92 in the High Court. So it illustrates that the High Court was successful in calming things down. Section 92 had less significant effects, restrictive effects, post-Whitfield. Vis-a-vis intercourse, the 5 cases were ACTV and Nationwide News in 1992, the original freedom of political communication cases, Cunliffe and Commonwealth in 94, AMS and AIF in 1999, and APLA and the Legal Services Commissioner in 2005. Now, in all of these, the Section 92 arguments vis-a-vis intercourse were very much secondary to the main issues in the case. In the first 3, ACTV, Nationwide News and Cunliffe, the main focus was what we now call the implied freedom on political and government matters. And in APLA, the main argument was, in effect, a variation on the theme, to put it broadly, vis-a-vis what might be called governmental communication. So the arguments about intercourse were very much secondary, and I'll come to AMS and AIF shortly. The only case in which these arguments about intercourse met with any success at all was in Cunliffe, in the very limited sense that Chief Justice Mason, in dissent, held that one aspect of provisions that he felt invalid under the freedom of political communication would also have been invalid under Section 92, and that was in dissent. No other judge in the High Court has invalidated anything under the intercourse limb since Cole and Whitfield. In AMS and AIF in 1999, at issue was a family court of Western Australia order that required a mother who had principal residence in Perth and principal custody of a child. An order was made directed to her requiring, limiting her ability to change the child's principal place of residence. You may know that it's the sort of order family courts make from time to time, and it's very controversial for obvious reasons. The High Court allowed her appeal against that order by a 6-to-1 majority, but based on non-constitutional reasoning. But there is some discussion in the case of the intercourse issue. In none of these 5 cases was there any clear joint unanimous approach taken to the intercourse limb. But importantly, in none of the judgments was it held that Section 92 vis-a-vis intercourse was limited to laws which discriminated against interstate intercourse or movement, with 1.5 exceptions. But for those 1.5 exceptions, all members of the court who dealt with it held by at least implication that the intercourse limb could apply to general non-discriminatory laws. So in Nationwide News, it was general laws of the relating to the Industrial Relations Commission. In ACTV, it was general federal laws about political advertising. In APLA, it was New South Wales laws about lawyers advertising. The one clear exception is Justice Toohey in Cunliffe, who rejected an argument that freedom of intercourse may be impaired by a law of general application, and held there was no breach of Section 92 because the law applied indifferently to intrastate and interstate communications. The half exception is Justice Brennan, with great respect to his honour, who stated that the guarantee is not limited to discriminatory laws, but in substance his approach did seem to really involve discrimination. It's also arguable, although unclear, that in various of the post-Cole judgments it was implicit that a stricter approach would be taken to discriminatory laws, although it was never dealt with very clearly with respect. A majority view did emerge in AMS and also in APLA as to the justification test that would be applied to laws which were discriminatory, namely, quote, whether the impediment so imposed is greater than that reasonably required to achieve the objects of the legislation. So then let me turn to the difficulties that at least I perceived with this approach. In a paper that I wrote and presented to an ANU seminar honouring the memory of Professor Leslie Zines in September 2019, which was published last year, I was critical of where the High Court's case law on intercourse had got to, and I advocated that the 2 limbs of Section 92 should be reintegrated, achieving that by limiting the application of the intercourse limb to unjustified discriminatory laws, such that it did not apply to general laws which applied equally to interstate and intrastate movement. In brief, my key arguments were as follows. First, at the heart of the notion of intercourse among the states is movement, whether of persons, goods, services, electrons, electromagnetic waves, or anything else, so much as implicit in the notion itself and in the case law, going back before Cole. As recognised in that case law, trade and commerce across state borders itself involves movement necessarily, and thus intercourse. Thus, all trade and commerce involves intercourse. However, not all intercourse involves trade and commerce for obvious reasons. Nevertheless, in my view, the High Court was wrong in Cole to say that notions of absolutely free trade and commerce and absolutely free intercourse are quite distinct. With respect, that was to assert a conclusion with relatively little reasoning, and the conclusion's not supported by the text, as Sandy said at the beginning, echoing something Justice Haynes said in Appler. The text doesn't readily reveal any basis for treating one of the three elements of the composite expression, trade, commerce and intercourse, as being quite distinct from the other two. Secondly, and relatedly, by applying the intercourse limb to non-discriminatory laws, a significant potential disparity arises. Given that intercourse is taken to involve movement across borders and can encompass movements for commercial purposes, then if a different and broader test is applied to the intercourse limb, that potentially could undermine the limiting effect of Cole, overturning all the previous, or most of the previous approaches, on the trade and commerce limb. Put starkly, Cole rejected the individual rights view of Section 92, but the danger was that you could get back to that sort of approach through the intercourse limb. And general non-discriminatory laws could thus meet Section 92 problems again. A resolution to that problem was suggested by Chief Justice Spiegelman in the New South Wales Court of Appeal in a case called Cross and Barnes Towing in 2005, which was to only apply the Cole test to laws insofar as the laws dealt with commercial activity. But as His Honour noted, you'd still have to apply both tests insofar as a law regulated both commercial and non-commercial activity. That approach seemed to win the support of Justices Gummow and Hayne in Appler, but it still means there's at least some tension between the two limbs. Thirdly, and to my mind significantly, a real problem with the Cole approach is that the intercourse guarantee ends up as being rather odd in its operation. To explain why that's so, we just need to take a step back for a moment. For most constitutional guarantees in Australia and around the world and equivalent international guarantees, in substance there are two stages of analysis. One, does the law or the measure burden the protected interest? Two, if so, can it nevertheless be justified as sufficiently directed to some competing legitimate end? So for Section 92, vis-a-vis trade and commerce, this was applied as follows. One, the court assesses whether the law imposes a discriminatory burden on interstate trade as compared to intrastate trade, such as to materially burden interstate trade to its competitive disadvantage. And it's that competitive disadvantage which encompasses the notion of protectionism. You are protecting local trade from interstate trade. Two, if so, the court then assesses whether that burden can be characterised as justifiable to achieve any claimed legitimate object, i.e. non-protectionist object, which is an acceptable explanation or justification for the differential treatment, such that the law is then not characterised as relevantly, i.e. impermissibly discriminatory. And in Betfair number 1 in 2008, the High Court spoke of a test of reasonable necessity in that regard, and it's here where the issue of the proportionality dispute comes in, which Shipra is going to talk about. On the Cole test, vis-a-vis trade and commerce, few laws fail at the first step. Contrast, incidentally, freedom of political communication, where most laws, where there's any serious dispute, do. On the Cole test, few do. In that context, it is justifiable and, in my view, appropriate that the justification test is applied reasonably strictly, because you only get to that if you've established some kind of protectionist discrimination. And any such protectionist discrimination requires, in my view at least, consistent with the guarantee, a significant degree of justification. And that's what the reasonable necessity test seemed to imply in Bitfair number 1, and that's how it was applied in Bitfair number 1. For the intercourse limb, however, the situation's quite different. Most laws fail the first test. Take the law in APLA restricting me in New South Wales from advertising my services in particular ways back then. It was non-discriminatory. It applied to any lawyer who happened to come into Western Australia. It applied to Queensland lawyers seeking to advertise in New South Wales, I should say, seeking to advertise in New South Wales. It's a general law, but it did restrict people in Queensland wanting to advertise their services in Sydney. So the law failed the first test, and you had to get into a justification analysis. But applying that test I articulated, the justification analysis is very readily satisfied. So you end up, and it has to be, because most laws are being subject to this level of scrutiny. So you end up with this very odd situation, in my view, where, remember, the reason for the High Court to differentiate the two limbs was that intercourse is more protective. But you end up with a situation where most laws fail the first limb of analysis, but you then have to apply a very loose justification analysis at the second level, so most laws are readily satisfying the requirement. And you also get the feeling that the real issue bubbling away, and that's reflected, for example, in Justice Brennan's judgment that I referred to in Nationwide News, is not that we're really seeking to protect Queensland lawyers who seek to advertise in New South Wales distinctly from New South Wales lawyers. Broadly, we're concerned about acting, New South Wales, to take that example, acting to the disadvantage of Queensland and outside lawyers, or vice versa. So that comes to the notion of discrimination. In terms of the resolution of the dilemma, what I suggested was that a discrimination test should also be applied to the intercourse limb, but in a particular way, namely the focus is unjustified discrimination against interstate movement, because movement is the essence of intercourse, as opposed to intrastate movement. And that is consistent, in my view, with the purpose of Section 92 as recognised in Cole, namely, quote, to create a free trade area throughout the Commonwealth and to deny to Commonwealth and states alike a power to prevent or obstruct the free movement of people, goods and communications across state boundaries, unquote. Now that purpose doesn't require that preferential treatment be given to people coming from interstate, but that equal treatment be given, hence the focus on discrimination. This approach was in substance adopted by each of the 5 members of the High Court sitting in Palmer after the excellent advocacy of the Queensland Solicitor-General, admirably supported by Felicity Nagorka and Kent Bloor. And to be fair, it was also adopted in reply by counsel for Mr Palmer, for whom Peter Dunning was appearing. Their honest reasons for taking that approach varied slightly between themselves and compared to mine, and in Justice Edelman's case perhaps departed fairly significantly from some views I'd expressed, but all came to the same position, at least as regards intercourse. To give you a flavour, Chief Justice Kiefel and Justice Keane stated at paragraph 62 that Section 92 precludes, quote, a law which burdens any of the freedoms there stated, where the law discriminates against interstate trade, commerce or intercourse, and the burden cannot be justified as proportionate to the non-discriminatory legitimate purpose of the law which is sought to be achieved. There were 2 notable differences within the judgments. First, Chief Justice Kiefel, Justice Keane and Justice Edelman stated, as reflected in the quote I just gave, that the justification test to be applied was the notion of structured proportionality as has been developed in the freedom of political communication context. Justices Gageler and Gordon considered, consistently with their views expressed in relation to the implied freedom, that a looser characterisation approach should be adopted, and Shipra will say more about that. The second difference was that Justice Edelman distinctly gave lengthy reasons for why His Honour considered protectionism was not required in applying Section 92 vis-a-vis trade and commerce, although he did state that this issue, after some 8 pages of analysis, that this issue need not be finally resolved. No other judgment expressed that view about protectionism, and indeed one would have to say, I think, that the other judgments were inconsistent with any such rejection of that aspect of Cole and Whitfield. Would note, although it's not the subject of my talk today, that was the other topic which I addressed in substance in my chapter last year. Turning then briefly to the interaction between trade and commerce and intercourse now. If one takes the view that characterisation of a measure as protectionist is still required, as all do except perhaps Justice Enelman, and perhaps even if one does not, there are still going to be some differences between arguments focused on trade and commerce and those focused on intercourse. So they're not completely identical. For trade and commerce under Cole, the discrimination must be against interstate trade, such as to benefit local trade. It involves economic analysis. For the intercourse limb, it's not about economics. The focus is on discrimination against interstate movement as compared, in my view, to intrastate movement, which does not involve economic analysis. Relatedly, a law discriminating against interstate movement may not confer any advantage on local movement. So compare the situation vis-à-vis trade and commerce. To give you an example, it may be an advantage for a state to seek to keep people out with, say, criminal histories, to evoke a previous High Court case. But that advantage is one generic to the state. It's not advantaging people moving within the state. It's hard to see it's advantaging local criminals or some such thing. So the analysis is not identical. Nevertheless, while this may come to be sorted out in the cases in the future, I don't think that causes intractable problems. And I would add this, that in my view, as I expressed in the article, successful challenges on the intercourse aspect will be very rare, because it is to be expected that few laws would be found to target interstate movement in this way. That being said, Palmer was about one such law, because it clearly did target interstate movement. So it did fail the first stage of analysis and got into the second in a way. But that's where we get to and noting the time, I'll be very brief about this, but that's where we get to this issue about statutory discretions. The answer to the stated question was expressed very carefully and was about the statutory powers and not the particular exercise of those powers in relation to the directions the Police Commissioner had made. That was, as I indicated earlier, kind of a neat sidestep for the High Court, with great respect to them, of the same kind as had been performed in Watton and Queensland in the implied freedom context. I'm not suggesting, by the way, it was an illegitimate sidestep, but it did mean that the directions themselves were not tested against Section 92 on the basis that the court held the statutory powers which empowered the directions were sufficiently constrained, such as to be seen not to offend Section 92, at least in circumstances of potential plague or epidemic. So incidentally, the facts found by Justice Rangier in the end were of secondary importance. In a sense, what they did is illustrate the sorts of things that arise when you face a pandemic or a plague. But it wasn't as though it was the particular circumstances of this pandemic and plague which were used to test the particular directions made by the Police Commissioner. There's a lot of complexity, actually, about seeking to challenge statutory discretions for breach of a constitutional guarantee. And it may be that I'll say something more about that in questions if it comes up. But I think at this point I should probably cease and desist and hand over to Sandy and then Shipra.
Thank you, Jeremy. Well, we'll move, because we are getting on in time, directly to Shipra. If you can take over from there, Shipra. Can you hear us? There she is.
Hi, yes, I can hear you. Can you hear me?
Yes, we can. Thank you.
Right. All right. So I just wanted to start by acknowledging and paying my respects to the Gadigal people of the Eora Nation, who are the traditional custodians of the land from which I speak to you today. And I pay my respects to their elders, past, present and emerging. Also, just a quick thank you to the AACL and the Bar Association of Queensland for the opportunity to speak today. Sandy and Jeremy have already given you an excellent exposition of why Palmer and Western Australia is a significant case in the development of Section 92 jurisprudence. And one of the reasons which Jeremy touched on as to why it is so significant is that structured proportionality has now been accepted by a majority of the High Court as applying to both limbs of Section 92 for the first time. The interaction between this development and the doctrine that was established in the seminal case of Colin Whitfield will be the focus of my talk today. I'm going to proceed in three broad parts. I'll start with an overview of the position taken by the court in three critical cases that preceded Palmer and Western Australia, and those are Colin Whitfield, with which most members of this audience will be familiar, Castlemaine Tuies and Betfair Number 1. I'll then discuss the approach adopted by each member of the court in Palmer and Western Australia in respect of the application of structured proportionality in the Section 92 context. And I'll consider the reasons that were given in support of accepting and applying structured proportionality, and also the objections raised by Justice Gagler and Justice Gordon. And in concluding, I'll make some brief remarks about the implications of the various approaches for the doctrine that was established in Colin Whitfield. So Colin Whitfield is probably one of the most well-known Australian constitutional cases. Jeremy has already touched on it in his presentation, and it doesn't need much further introduction to this audience. But I thought I might nonetheless recap on some of the principles that were established in that case, insofar as they're relevant to the way that the doctrine has developed in Palmer and Western Australia, because they're quite important to understand the doctrinal shifts. So, as you may recall, Colin Whitfield concerned regulations on the size at which crayfish could be bought, sold and possessed in Tasmania, even if their origin wasn't Tasmanian. And the complainant challenged the regulation as being an impermissible burden on the freedom of trade and commerce in Section 92. The High Court unanimously dismissed that challenge, and in doing so, they made a number of significant observations. The first was to accept that the relevant test, at least for the trade and commerce limb of Section 92, was whether the law imposed a discriminatory burden of a protectionist kind. If it did, the law was invalid. And in the court's view, this aligned with the purpose of the section, which was to create a free trade area throughout the Commonwealth, or in other words, an absence of protectionism. The second significant observation, which Jeremy has also noted, was to highlight that the guarantee in Section 92 was not an absolute one, and it couldn't be an absolute one, because for trade, commerce and intercourse to be absolutely free of any kind of regulation would inevitably result in anarchy. And the third critical observation of the court was to identify that when deciding whether a law infringed upon Section 92, consideration needed to be given to the form of the legislation, or where the practical effect of the law was protectionist, the purpose of the legislation. And in that regard, the court said, a law which has its real object, the prescription of a standard for a product or a service or a norm of commercial conduct, will not ordinarily be grounded in protectionism and will not be prohibited by Section 92. But if a law which may be otherwise justified by reference to an object which is not protectionist discriminates against interstate trade and commerce in pursuit of that object, in a way or to an extent which warrants characterisation of the law as protectionist, a court will be justified in concluding that it nonetheless offends Section 92. So it might be said that what the court did in Colin Whitfield was take a definitional approach to the trade and commerce limb of Section 92. Where a law was protectionist in its purpose, the law would contravene the constitutional guarantee and be invalid. In Castlemaine Tui's, the majority cited and affirmed Colin Whitfield extensively. In doing so, the majority compared the doctrine that had developed in the US in relation to the Commerce Clause. And in that doctrine, they compared the doctrine that had developed in relation to that clause with the doctrine that had developed here in respect of Section 92. And the court observed that the difference was that the American balancing process is carried out only after a law has been found to be directed towards a non-discriminatory purpose, so that the burden on interstate commerce is incidental to that legitimate purpose. In contrast, we are concerned with only the proper characterisation of the law as protectionist or not, and that's in the sense that was described in Colin Whitfield. So there's no place for a secondary test, the court said, to invalidate laws which have been found to lack a protectionist purpose or effect. Rather, the two tests are combined as one inquiry into the characterisation of the law as protectionist or otherwise. And as to the role of balancing or proportionality, the majority observed that the fact that a law imposes a burden upon interstate trade and commerce that is disproportionate to the attainment of the legitimate object of the law may show that the true purpose of the law is not to attain that object, but to impose the impermissible burden. So in other words, to the extent that the concept of proportionality was relevant, it was relevant to the process of characterisation of the law as protectionist or otherwise. The observations made in Castlemaine Tui's were further elaborated in the more recent case of Betfair No. 1, and that concerned the validity of Western Australian laws prohibiting access to betting exchanges, including those run by interstate operators. Under a heading entitled Acceptable Explanation or Justification, the plurality in Betfair No. 1 considered submissions made by Western Australia that the regulatory prohibition that Western Australia had placed on betting exchanges was justified on the basis that it was to counter a threat to the integrity of the racing industry. And in answer to that submission, the majority observed that Western Australia could have adopted a similar regulatory path to that which had been taken by Tasmania. And if it had done so, that would have protected the integrity of the racing industry without imposing a discriminatory burden. It was on the basis of the availability of this reasonable alternative that the majority observed that the law was not proportionate. The majority concluded that the law was not appropriate and adapted to the propounded legislative object. And so ultimately, despite the use of the language of justification, Betfair No. 1 represented no real departure from Colin Whitfield and Castlemaine Tui's. The task for the court remained to determine whether the law was pursuing a protectionist object or a legitimate non-protectionist object. Where there were available non-protectionist alternatives, this suggested that the law was pursuing a protectionist object. In that context, proportionality had no greater role to play in describing, no greater role to play other than describing that there was no real necessity for the impugned law since there were available alternatives. Proportionality wasn't used as an overall test of justification, as it has been in the context of the implied freedom of political communication, and it didn't involve balancing the importance of a law against the degree of incursion into the guarantee. Turning now to the decision in Palmer and Western Australia, 3 of the 5 members of the court in that case accepted and applied structured proportionality in respect of both limbs of Section 92. You might recall that McCloy-style structured proportionality involves 3 stages of analysis. At the first stage, the court asks whether the law has a rational connection to a legitimate end. At the second stage, the inquiry involves asking whether there are reasonable alternatives to the law that have less impact on the constitutional guarantee. And then at the final stage, which is the most controversial, the court asks or evaluates whether the importance of the law is greater than the degree to which it infringes on the protected interest or guarantee. And if a law fails at any one of these stages, it is invalid. In their joint judgment, Chief Justice Kiefel and Justice Keane put forward a number of reasons to support their ultimate view that structured proportionality was an appropriate tool in the Section 92 context. Their honours did not expressly disavow the definitional approach that had been taken in Cole and Whitfield, but they considered that establishing that a law was not protectionist was not on its own enough to establish validity. In Cole and Whitfield, their honour said, the law's character as non-protectionist was not the only feature that saved it from invalidity. Rather, the law was found to be reasonably necessary to prevent undersized crayfish from being caught in Tasmanian waters. So in concluding that determination of the law's character as protectionist or otherwise is a separate stage of analysis to whether it is reasonably necessary, it might be said that Chief Justice Kiefel and Justice Keane departed from the view that had been expressed in Castlemaine-Tooheys, that the assessment of the necessity of a law was part of the process of characterisation. Chief Justice Kiefel and Justice Keane then pointed to a number of indications in support of their view that the task for the court was an evaluative one involving balancing interests, to which the adequate in the balance stage of structured proportionality was suited. First, they said that in Betfair number 1, the majority had considered the justification put forward by Western Australia and concluded that it could not justify the impugned law in that case. Second, in cases preceding Cole and Whitfield, reference had been made to impugned laws being no more restrictive than required by the public interest. And this was said to involve some balancing of the law against the public interest. And then third, their honours noted that a notion of balancing had been considered evident by Professor Zines in Castlemaine-Tooheys. And on this basis, Chief Justice Kiefel and Justice Keane reached the conclusion that once it is accepted that a discriminatory law may be justified as reasonably necessary in the sense that it that is understood in proportionality analysis, there seems no reason why it should not be justified as adequate in its balance. That is, not only would the court be concerned with asking whether there are reasonable alternatives to the law, but the court would also consider the importance of the law compared to the burden placed on the freedom in Section 92. Where the burden was great, but the importance of the law was trivial, the law might be considered invalid. In applying this approach, Chief Justice Kiefel and Justice Keane accepted Western Australia's submission that the Emergency Management Act provisions were pursuing a legitimate, non-discriminatory purpose of protecting public health. But that was not the end of the inquiry. Their honours observed that proportionality in the strict sense had to be applied such that it was necessary to measure the importance of the public health purposes against the extent of the restriction of the freedom. And on that front, their honours concluded that although the restrictions were severe, their importance in the protection of health and life justified the severity of the measures. One of Justice Edelman's overarching concerns was that if the two aspects of Section 92 have different tests, there will be an inevitable tension between them. And Justice Edelman's preferred resolution of that tension was to shift away from the view that the Trade and Commerce limb applied only to protectionist discrimination. His honour's preference was that both limbs would apply in relation to discriminatory burdens of any kind. On one hand, Justice Edelman considered that the tension that he'd identified did not need to be resolved in this case, since the protectionist element in the test for the Trade and Commerce limb had not been challenged by any party. On the other hand, His Honour expressly put aside the issue of protectionist discrimination on the way to concluding that structured proportionality applied to both limbs of Section 92. And the effect of His Honour's approach was to disregard protectionist discrimination as the touchstone of the trade and commerce limb, even while not formally doing so. As to structured proportionality, His Honour's approach aligned with that taken by Chief Justice Kiefel and Justice Keane in their joint judgment. Justice Edelman saw no difficulty with adopting each of the three stages of structured proportionality analysis in this context. His Honour considered that the development of a transparent and concise test of discrimination should not be undermined by a vague and opaque approach to justification. Structured proportionality would complete the movement towards transparency. In relation to the third strict proportionality stage of analysis, His Honour acknowledged that it required comparing the importance of competing policies upon which Parliament is far better suited to judge in a representative democracy. And in light of that acknowledgement, His Honour considered that the third stage only applied in the most extreme examples of laws whose legitimate but trivial purpose could not justify an extreme burden on freedom. By contrast, once again, Justice Gageler emphatically rejected structured proportionality as an appropriate tool to carry out what His Honour described as a justification exercise. In doing so, however, Justice Gageler made a number of important concessions as to the matters on which he was in agreement with those who preferred structured proportionality. So Justice Gageler accepted that for validity, there needed to be a degree of connection between the legislatively chosen means and the legislatively chosen ends. And that is an analysis which broadly maps to the suitability stage of structured proportionality. His Honour also accepted that there may be utility in considering whether there are available alternatives, and that maps to the necessity stage of analysis. And then finally, His Honour considered that the need may arise to consider the systemic benefit of achieving the legislatively chosen ends relative to the systemic detriment caused by the impact of the legislatively chosen means on the freedom. And that maps to the strict proportionality stage of analysis. So Justice Gageler's view, or in his view, there was no objection to the various tests that make up the stages of structured proportionality. His Honour's objections were more limited. The first reservation that Justice Gageler had was that structured proportionality involves the judicial importation of a tool of analysis forged in a different institutional setting with a different intellectual tradition and social and political milieu. And there he is referring to structured proportionality's German administrative law origins. The second concern that Justice Gageler expressed was that structured proportionality is rigid. And this is a concern that His Honour has expressed in a number of implied freedom cases. In His Honour's view, the sequencing and the linguistic precision of the three-stage tests tends to obscure the purpose for which the overall inquiry is undertaken. The third of Justice Gageler's concerns was that structured proportionality might cause factors that would otherwise be irrelevant to the inquiry to receive unwarranted analytical prominence. And then on the other hand, factors which ought to be given more prominence would be ignored or downplayed or distorted. On the issue of structured proportionality, Justice Gordon's objections can be divided into two broad camps. The first was a general set of objections to the use of structured proportionality in any constitutional context, including the objection raised by Justice Gageler as to the rigidity of the method. The second was a more specific set of objections to the use of structured proportionality in the context of Section 92. In relation to the second set of objections, Justice Gordon considered the difficulty with structured proportionality analysis was that it did not necessarily assist with the task of characterisation of a law as either achieving a legitimate object or affecting a form of prohibited discrimination. And in this sense, Justice Gordon's reasoning harks back to the line of cases that I referred to earlier in my talk, most closely out of all of the justices' reasoning in this case. So Her Honour observed that the absence of alternative means may suggest that the purpose of the law is in truth to achieve the legitimate purpose alleged. But to treat the existence of alternative means as conclusive of validity, which is what would happen if it were a stage of structured proportionality, would be too rigid and too prescriptive and fail to accommodate the specific circumstances in issue. Her Honour further observed that the introduction of strict proportionality added a new step of analysis into Section 92 that would be contrary to the foundations and the current operation of the provision. The balancing stage of structured proportionality required a value judgment between the importance of the purpose served by the restrictive measure and the extent of the restriction it imposed on constitutional freedom. And in Her Honour's view, Section 92 neither permitted nor required this further inquiry. The adoption of structured proportionality represents, or in this specific context, represents a significant shift away from the doctrine established in Colin Whitfield and followed in Castlemaine Tooheys and Betfair No. 1. The prevailing approach no longer relies on identifying a protectionist or non-protectionist purpose, as in those earlier cases. Now, if a law is characterised as being protectionist, if a law is characterised as not being protectionist, that is not enough to save it from invalidity. In addition, the law must be shown to be reasonably necessary in the sense that there is no reasonable alternative that infringes upon Section 92 to a lesser degree. And most controversially, the law's importance is also now relevant to the assessment. If the law is not protectionist but is also not sufficiently important, it may still be found to be invalid. These developments mark a progression away from the definitional approach set out in Colin Whitfield, which was based on characterisation, and move towards an evaluative justification approach. It had been accepted in Castlemaine Tooheys that whether a particular legislative enactment is necessary or even desirable is in large measure a political question, best left for resolution by the political process. That is perhaps no longer the case. Protectionism was selected in Colin Whitfield as the touchstone of the kind of discrimination that was relevant to the trade and commerce limb of Section 92 because it aligned most closely with the drafting history of that provision. That is, the purpose of the provision was to create a free trade zone. The purpose of the provision was not to prevent any kind of regulatory discrimination. One might query whether moving away from a protectionist purpose as the touchstone of the trade and commerce limb will have unintended consequences. It may make this area once again fertile ground for endless judicial challenges, since discriminatory burdens that are not intended to be protectionist may arise in countless statutory contexts. It's not difficult to imagine that the imposition of any local regulation on trade and commerce within a state, which has the practical effect of not applying to interstate operators because of the nature of their trade, may be challenged as imposing a discriminatory burden, which would then need to be justified in the context of litigation. Putting those concerns aside, in my view, if the court is to move away from identifying a protectionist purpose as the means by which to determine validity under the trade and commerce limb, it should do so only when that aspect of Colin Whitfield has been squarely challenged by a party in a proceeding. The way in which structured proportionality has been adopted and applied by the majority in this case disguises a significant jurisprudential shift away from Cole and Whitfield. On the other hand, if the court were to expressly decide that protectionist discrimination is no longer the touchstone of trade and commerce, or the trade and commerce aspect of Section 92, then there would be less difficulty in accepting that structured proportionality has a role to play in respect of both limbs of the provision. Unconstrained by any definitional approach, there is no reason why discriminatory burdens on both limbs cannot be assessed in the same manner as purported burdens on the implied freedom of political communication. In both cases, there is a freedom guaranteed by the Constitution, the precise boundaries of which cannot be settled outside the specific circumstances of a particular case. In that context, there is a role for evaluative decision-making involving the contextual balancing of any competing interests. It might be accepted that structured proportionality is not a perfect solution to the problem of values-based decision-making, but I think it's also a mistake to conceive of it as an overly rigid set of rules. The stages that make up structured proportionality guide analysis. They are open to being applied at various intensities of review that accommodate institutional concerns about legitimacy. The strict proportionality stage in particular is well suited to taking into account the broader philosophical concerns underpinning the constitutional freedoms and guarantees to which it's applied. And once it's accepted that the stages of analysis that make up structured proportionality deal with legitimate concerns in the types of problems to which it's applied, it's difficult to see why the general objection to structured proportionality persists. That objection is not sustained by the complaint that structured proportionality has its origins elsewhere. If it's a good fit for local circumstances, it is appropriate to use it. However, unless and until the doctrine established in Cole and Whitfield is expressly disavowed, the introduction of structured proportionality into Section 92 jurisprudence is likely to jar with the traditional approach that looks to identifying a protectionist purpose. This is liable to lead to further confusion and to undermine proportionality's stated advantages of structure and transparency.
Thank you, Shipra. We have a question, well, it's really two parts, directed to either or both speakers, although I warn you that it comes from level 11 Wentworth chambers.
So that'll be a good question then.
So you should perhaps take note of this question carefully because it's preceded by a statement. The legal conception of discrimination often involves consideration of whether differential treatment is justified or not. That is, differential treatment is not legally characterised as discrimination unless it is not justified by reference to some difference in circumstances. That's the introductory proposition. Questions: does this apply in relation to the intercourse limb of Section 92 before one gets to proportionality testing? Second question, or is the question of justification subsumed within proportionality testing, that is, justification by reference to the legislative purpose? So I throw that open to
Shall I perhaps go first and then Shipra a second? And thank you for the excellent question to my colleague in my chambers at 11 Wentworth. And with respect, it's a very good question. And it raises an area with which, if I may say so with great respect to Shipra, I disagree in part with her analysis. So let me explain both of those points. The premise of the question is quite correct with respect, and indeed that goes back, if you look at a judgment often cited in relation to that nature of discrimination, is that of Judge Tanaka in 1966, I forget, was it the South West Africa case or something? It might have actually been in dissent, but it's seen as a classical judgment where he articulates this notion of discrimination, including the notion that it's not discriminatory if it can be justified as directed to some, and the language differs, but relevant distinction as opposed to an irrelevant distinction, or another way of saying that is as a justifiable point or not. Discrimination, in other words, on that sort of conception of it, amalgamates what I identified as the two stages. Is there a burdening of the protected interest, whether that is freedom of political communication or non-discrimination based on sex, race, sexual orientation, whatever. But then you get to the second stage analysis. If there is such discrimination, prima facie, is that justifiable? Now that's a process of characterisation. You can call it characterisation. So you can say if it is justifiable, it's not relevantly discriminatory, what the High Court said in Castlemaine Toohey. So although, as Shipra said, the High Court purported, with great respect to it, to say we're not like the Americans, we only have one stage. In substance, there is two. It was not so clearly articulated in Cole, it was pretty clearly recognised in Castlemaine Toohey's. And yes, they said there's one test, there's not. There's always been two, because the notion of discrimination has always involved those two. That's why I don't see, I respectfully disagree with Shipra, I don't see there being any significant departure, perhaps from a greater degree of analytical clarity, in recognising there are two stages of analysis. There isn't a bubbling issue which is bubbled away from the beginning, from Cole and Whitfield and then Castlemaine Toohey's, as to whether we're really engaged in just a characterisation of the purpose of the measure, or whether we're also more concerned about effects. So just because the Parliament was genuinely trying to do X, if the effects are bad, it still may be invalid. And having appeared in a number of Section 92 cases, I am yet to really discern clearly in the post-Cole world which one it is. And Amelia Simpson wrote an article in the Federal Law Review, I think in 2005 or so, saying it should be purpose. And there's a decent argument for that, and there's decent arguments the other way. I'm not sure it's clearly been resolved. So to come back to my colleague's question, I think clarity is added, and this is aside from what test of justification you apply, which is the proportionality debate. Clarity is added if you recognise there are two distinct elements, and the first, or two distinct stages, I should say. The first is there a burdening of the protected interest? Is there relevantly prima facie protectionist discrimination or discrimination against interstate movement? If there is, can it be justified by whatever your test of justification is? And by the way, Justice Gageler, who doesn't like proportionality, the section of his judgment dealing with it is called something like justification. So he's on it to recognises correctly, with respect, there are two stages of analysis. But Shipra may disagree.
Shipra.
Well, actually, I don't fundamentally disagree. I think the part where I probably depart, or the place where I probably depart, is that we still have the doctrine that was set out in Cole and Whitfield, which sets up this definitional approach. And while that definitional approach isn't overridden in any case and continues to apply, it's very difficult to see why there should be a general test of justification applied to deciding at least the trade and commerce limb of Section 92. But if we moved away from protectionist purpose as being the touchstone, then I agree with Jeremy. I think that there are two stages to the analysis: identifying the burden and then looking to see whether there is a justification for that burden. And that would not be dissimilar to the approach that's taken in the implied freedom context, and there's no reason to take a different approach. So really the thing that I think is the blockage to accepting that is the approach that was set down in Cole and Whitfield. But if we move away from that, and if the court expressly embraces moving away from that, then I agree with Jeremy.
Thank you, Shipra. So we have a further question from one of our audience, and this is one specifically directed to Jeremy. Do you think Chief Justice Kiefel and Justice Keen's formulation of the test for Section 92 seem to imply that protectionism has no role to play for the first limb of Section 92, bracket, although their honours do not explicitly refer to this like Justice Edelman, close bracket. This is as distinct from Justice Gagler and Justice Gordon, who seem to draw an explicit distinction between the types of discrimination required by retaining protectionism discrimination for the first limb of Section 92, but not requiring it for the second limb.
The answer is no. I don't discern that. I agree that paragraph 62, which is actually the bit that I read out, does not use the word protectionist. But on my reading of their honours judgment, nowhere in there is there any suggestion that protectionism is no longer required as regards trade or commerce. And that would be a substantial departure, of course, from Cole and Whitfield, and as Justice Edelman acknowledges, by the way, would mean Norman and the Barley Marketing Board, or his honour correctly implies, was wrongly determined. So that's a joint unanimous decision of the High Court in 1990, was probably wrongly determined. And indeed, as I say in my article dealing with protectionism, it would also mean that Betfair number 2 and Sportsbet, where this issue was raised by questions by the court, by written questions by the court subsequent to argument, but then they didn't deal with it. Although, as I point out in my chapter, although they didn't deal with it, the way they actually dealt with the argument is inconsistent with the suggestion that protectionism is not required. And to put that simply, and here I'm agreeing with something Shipra said, if you dump protectionism as an element for trade and commerce, you're moving towards a more European approach, and the focus then is discrimination. For similar reasons to what I put for intercourse, the nature of laws is to discriminate. If you say you can't do X, or your product must meet standard Y, you discriminate against me who wants to do X, or is in the habit of doing X, and you discriminate against me because my product doesn't meet standard Y. Laws discriminate, that's what they do. They create criteria by which penalties are applied, etc. Every law, in a sense, discriminates, and that's, by the way, why the Equal Protection Clause in the US is such a broad encompassing guarantee, because essentially every law can potentially come into it. You then have to engage in a justification analysis, my second stage. And so that's what the Europeans potentially do. So it doesn't matter if the law is exactly discriminatory. If it's burdening competition by inhibiting some competitors, then you have to move to the justification analysis. And my view, my personal view, is that in the absence of a clear textual foundation, which the Europeans have, but we don't, in my view, the court should not move into seeking to review all those sorts of laws and apply justification analysis. And as Shipra said, with that sort of move, you're heading back towards the old days of Section 92, where there's kind of a prima facie breach of most laws subject to assessment of reasonable regulation, to use the old-fashioned language. So to me, that would be a very retrograde stretch. To come back to the question, I don't discern that in the Chief Justice and Justice Keen's judgment, but I've only read it twice.
Shipra, did you wish to comment on that question?
I agree with Jeremy that the Chief Justice and Justice Keen have not expressly addressed this issue, but I think it is implicit in the form of the reasoning that they adopt, in particular in relation to structured proportionality, that they're really moving away from protectionist purpose as being the key, well, really in Colin Whitfield, the sole test. So by saying that we don't disavow that test, but we say that there are additional requirements that that a law needs to meet, they're really dismantling the in and out nature that definition gave to assessing whether a law is valid or not. So the binary nature of that and the absolute operation of Section 92 within the scope of that definition, that has fallen away. And if that falls away, then the utility of protectionist purpose and identifying protectionist purpose really does fall away as well. So I think, although they haven't expressly done it, it is implicit in their reasoning.
Now, in the interest of fairness, because I've been taking questions out of the ether, are there questions in the room? Anybody like to ask a question? Because I've got a lot of questions from the ether still to go, and I want to be fair to everybody. No other questions from the room. So can I ask this question? Would Mr. Palmer have been better off challenging the directions, or would the court have reached the same conclusion relying on the same or similar reasoning, because broadly speaking the factual and legal context was the same? I think it is right, incidentally, by way of comment, to say that the matter looked as if it might go off on a rotten point during the course of argument. But this is a question for you, Jeremy.
So this is a polite way of saying, was it Peter's fault? The answer, I think, is no. But it's a good question, and it raises this tricky issue of statutory discretions. The way the court approached it is to say, and let me seek to expand on it a little, this issue has played constitutional guarantees from the beginning, really, and particularly Section 92. There is a series of issues which arise, and they're quite complex and difficult. A first issue which arises is, what's the nature of the guarantee? Is it about protecting individuals or not? And you might think the simple answer to that question is, oh, well, Section 92 doesn't protect individuals, and by the way, neither does the implied freedom, because the High Court keeps telling us it's not a personal right. True, but even then it becomes a bit more complex, because it might still breach Section 92 by its effect on one trader, see Castlemaine Tuies or Betfair number 1, as a matter of characterisation, not as a matter of individual right. So effect on individuals can matter. But there's also been this issue about broad discretions, and that's what the Section 92 cases over the course of the century really struggled with, and the High Court was very suspicious, with good reason, for broad statutory discretions, because then you pass this broad law about, we'll regulate road transport, and then just sort of take these protectionist or discriminatory or whatever you don't like measures under the cover of executive action with no obligation to give reasons, and where it can be difficult to challenge. In a case called Miller and TCN Channel 9, or vice versa, in 1986, Justice Brennan said, look, it may be that administrative law has got to a point where we can start grappling better with that. And that judgment was referred to by a number of the judges in Palmer, because administrative law was seen as being better able to grapple with it. So the way the High Court approached it here was to say, look, Section 92 is not about individual rights, so I'm paraphrasing. So we're looking not at the effect on particular individuals, but on whether the statutory powers infringe Section 92, and they don't, because they're constrained. They're constrained by the express criteria of emergency and hazard and blah-de-blah-de-blah. They're constrained by implied criteria of reasonableness and so forth. And taking it as a whole in its statutory context, we're persuaded that that power is sufficient to meet the Section 92 requirement. And they did much the same thing in Comcare and Banerjee. You'll recall about at La Legal, the Department of Immigration public servant who tweeted under an anonymous handle. The issue there was judged by reference to the statute, not the particular application. And otherwise, we would be in circumstances, and so although I call it a sidestep, I do have some sympathy with what the High Court's done in Watton and in Comcare and here, because otherwise, potentially every exercise of governmental power which might affect freedom of political communication goes through the two-stage analysis. Does it burden freedom of political communication? If so, is that exercise justifiable? It also came up in a case I was involved in called Gaynor, not the High Court one, but about the firing of Major Gaynor from the military reserve. And again, we put that analysis to say it should be judged at the level of the firing power, not the firing of Major Gaynor, and that was accepted and special leave was refused. So I do have a lot of sympathy with the High Court. That being said, as Justice Gageler acknowledged, if you still do have a very broad discretion, it may be possible that you will have to come back to some sort of analysis of particular exercises of statutory power, but this was not such discretion because it was seen as confined. Finally, I'd also note that in Comcare and Banerjee, the plurality noted that it is possible you would construe a particular statutory scheme as, for example, making freedom of political communication a mandatory relevant consideration. But that's as a matter of construction, not as a matter of general constitutional law. But in sum, these are actually very difficult issues and have been for 120 years.
Shipra, did you wish to make comment? I'm looking at you at the screen. I should probably be looking at you at the camera, actually. Did you want to comment on that last question?
I don't have anything further to add to what Jeremy's just said, so I'll just leave it at that.
Now, I think whilst there are more questions that have come out of people who are watching, or come from people who are watching electronically, we've run out of time. Before I thank our speakers and ask those present to join me in thanking our speakers, I just want to mention that there is a further AACL event to bring to your attention, and that will be a discussion in relation to Ben Breaker. It will be held at 5:15 p.m. on Tuesday the 27th of April 2021. That's the day after Anzac Day. It will be online with a limited number of places at the Crown Law Common Room in the State Law Building. And the speakers at that event will be Dr. Rebecca Annian Welsh, Senior Lecturer at UQ Law, and Felicity Nagorka, Assistant Chief Counsel at Crown Law. So can I implore everybody who's participated and watched today to also get engaged in watching that event in relation to the constitutional validity of a Commonwealth law that allows a state court to detain a person after the expiry of their sentence if they present an unacceptable risk of committing a terrorist offence. Now, having given you that notice, can I ask you all to join with me in thanking our speakers? These have been extraordinarily interesting and topical presentations. To my mind, Palmer is a seminal decision now in the line of Section 92 judicial consideration, and it potentially opens the door for reconsideration of Cole and Whitfield. Really an important case, I think. So I do thank our speakers for their considerable contribution, knowing how much time speakers have to put into presenting papers like this. I'd like everybody to join with me in thanking them.